Hi there, welcome back to the Dylan Rounds case. Welcome if you're currently here in the live premiere. Today is part 2, looking at Bibbins and his past criminal history to make sense of who he is, how dangerous, and is he worse than James Brenner? James Brenner being the key individual tied into the Dylan Rounds case and has been charged with the murder and desecration of Dylan Rounds. I want to look at it from a different angle, a different person of interest, to see is there any possible links, anything from the past which could link to the Dylan Rounds case, whether it be the outcome of something, Bibbins' attitude, his response at the time, anything similar to Brenner, any forms of crimes committed or details which link to how Dylan Rounds could have been taken out or impacted negatively. We're only going to know though if we, check for it, did a research. So that's what we're going to be doing today. We're going to be looking at, I think it's 1985 court document article when the court trial played out, and I guess it's the transcripts of it. I'm going to read through it. It'll make more sense later, so make sure to stick around. We also, and we can, check out the comments from the last video I did, the part 1 introduction of Bibbins, who he is, what he's all about, as told from the story and perspective of a Montello local who has known Bibbins for some time. Credit to them for their presence and them sharing their knowledge. Here we're getting into the deeper part, the aspect, the key details to try and understand it further, right? If you haven't already checked out part 1, the introduction, make sure to catch up on it. I'll try and provide a link somewhere. Top right corner of the screen, there will be a link to the playlist of the Dylan Rounds case. Over 400 videos made on it by my channel. If you have missed out on anything, all the videos will be there to catch up on. As for those that are currently in this live premiere, be sure to let me know your thoughts, your opinions and reactions to what we're going to be looking at today, the court documents, the transcripts, whether you're shocked or not, whether you can find any links that could apply Bibbins to the Dylan Rounds disappearance murder case. Be sure to let me know in the chat. And for those that may join late, a different day, leave your comments down below in the comments section, okay? In the comment section, pinned will be a message by me with some additional links if you wish to check them out. And once again, before we go any further, big shout out to Maria Moyano. Shout out, I shouldn't say the last name because it probably gets a bit cringy. Shout out to Maria, shout out to Cleo for their presence last night in Super Chats. Very good of them. And as well, the video that was done last night, quite an important one from a different perspective on the Kenny Veach M Cave mystery case, missing person one. If you are interested in other mysteries or missing people cases, be sure to catch up on my Kenny Veach coverage. It's much deeper than you think. Now, with that all being said and done, the order of how we're going to do things today is acknowledge the comments from the last video, catch up there. If there's any questions that need answering, I'll try and answer them. And if there's any other additional points of information or interest, that can be acknowledged too. And then once that's been cleared up, then we can move straight on into this court documents and see what it's all about. Okay, let's now head on over to the YouTube comments. So I'm just going to adjust it to the newest comments and then we can work our way up. Not too many. We got Classy saying, I accidentally touched the thumbs down, then I corrected it. Appreciate that. Yeah, it can happen at times, even like when it comes to liking or disliking comments. I don't know why they do have a thumbs down on the comments area, because okay, you like a comment, it'll show the number. If you click dislike, it doesn't show the dislikes. I don't know if that coincided around the time of when YouTube removed dislikes off YouTube videos. Still don't quite understand why they took that away. Bit silly, right? What else do we have here? We got Ronald saying, I know about other criminals in and around Montello. Ask me now, I'll tell you how. Oh, a bit of rhyme as well. Interesting. Well, if that's the case, anybody in the chat right now, you got any questions of interest regarding a certain criminal or potential criminal out there, someone that's been involved in the Dylan Rounds case or so, feel free to ask Ronald. He might have some information, might be able to answer your questions. We got Glenn, we got Cleo, interesting. What's this? Yeah. That's good, because I was going to be responding back to Cleo's comment because I needed to tell her something in a response, but I forgot where the comment was, but here we are. So, Kevin related, but I was just saying, Cleo, one of your short videos got 800 plus views on your shorts, so it performed well out of nowhere. Cleo says, thank you. Unfortunately, I'm just playing around at the moment with favourite things. This is the thing, Cleo, the key response. You shouldn't be saying unfortunately. You should be changing it to fortunately, that you're in a position where you can play around, where you can experiment based off your things, your favourite things, stuff you like, right? And on that occasion where you got 800 plus views on your shorts whilst playing about, clearly shows that something went right, and something that you like is something many other people like. So based on that, maybe apply it in the future. Whatever that cartoon animation thing was, if there's more of it or something similar, it's something that you like or interested in, maybe make more videos, short ones on that, and include the hashtag shorts, and it might perform well. Once a video has done well, unexpectedly, out of nowhere, Cleo, try and jump on aboard that to try and get that pattern, that growth going, right? It might not completely link, but when I was doing that first ever Kenny Veach video, just a bit of a casual one, pointing out a finding, and it suddenly, gained quite a bit of attention, and it shocked me because obviously I was a nobody back then, and it suddenly did well. So it was like confirmation to say, you did something right, Raf, try again, follow that pattern, that theme, and see where it goes. And here I am. So maybe you try that, Cleo, with your interest and likes when it comes to YouTube. And, if Cleo isn't watching this video yet, I'll just tell her afterwards to rewind back. But that was unrelated to Dylan Rounds, but I wanted to respond back. Linking back to the case, though, Juan says that place is full of bad guys, and I think probably referring to either Montello or Lucen, or combined together. I mean, as for the Lucen part, you look at the likes of Don Hatley, Brenner, Bibbins, all have a criminal history. Maybe one's worse than the other or so, but they're all got in trouble in the past, and Dylan Rounds is surrounded by those type of people. Any clean, good, normal, innocent ones out there? Maybe. You just don't really hear much about their names, right? Some may lay low. We got June saying, just start out every video saying you're a Democrat and Joe Biden is doing a great job. Your videos will never be messed with. Hey, you might even get a gold star. Maybe. And, if I change my, hair colour to a rainbow one, maybe, get some sparkles and glitter in, I'll probably get a big boost, right? Oh, great, perfect. We've got another person called June. So what's the difference between June TB and June Butchholtz? Two different people? Or is one a default profile and then the other one's the same? Just because of responding back on the same comment. You probably do get two different Junes, like how at one point you had two different Lindas. Anyway, comment here. We got Joseph Lloyd. Not seen Joseph Lloyd for a while. Where's he been? No clue. We got Pam saying both Bibbins, Brenner are just as bad as one another. Okay, fair enough. Oops. Cool comments here. We got Megs. Shout out to Megs popping on in again. Not seen them for a while. Came across them in the Kenny Veach case, which was good. Meg says the YouTube community and the Reddit community has done a lot to keep cases in the limelight. It's crazy. The news media has done much worse. At least you're sticking with it. And arguably, I'm probably one of the last or second to last individuals still covering the Dylan Rounds case, because with time, many people in the Dylan Rounds case have walked away because they can only do so much or listen to so much. Others have just given up and abandoned it. Some have just moved on to stuff that's more popular for views. But there is still one person standing, and hence the video today. Yeah. Anything else? I can't handle that this boy is out there dealing rounds somewhere, all these missing people. How's our technology not helped? Imagine if all these alleged psychics were actually real, there'd be at least 10 in every state. I'd go insane. I almost did go insane when, okay, that's why I disappeared. I haven't been right since. Humans do these things to humans, what the hell? They need to be caught. I'm glad people like you are outraged and dedicated and won't let it go. I mean, the thing is with me, I'm not outraged. I'm just here simply to cover a case or whichever one I'm doing at the time, right? As I said, there'll be people out there that are really emotionally invested in the Dylan Rounds case. And with that emotion can come clouded judgment, where people may go down the wrong path, may become vulnerable, listen to the wrong people, and then change in behaviour. I've seen that extensively already now, including outsiders and those some that were on my channel as viewers, whether they still are or not. It's happened, it's gone downhill, but it is what it is. Because I'm not putting lots of emotion in, I'm just simply covering it, I'm making the observations, I'm analysing, I'm not getting pulled down the rabbit hole in that sense, I'm not getting completely delusional, I'm taking it all into mind and maintaining the balance too, which really not many other people can. When some have tried, they've fallen. So, yeah, it's just covering it, trying to keep it somewhat controlled, trying not let this or that go too bad because it could impact your ability when covering it, right? So, I just say it's somewhat under control. Now, we've acknowledged the comments. A couple of people seem to believe that Bibbins is just as bad as Brenner. And to be honest, Bibbins and Brenner, how close are they together? As friends, associates, acquaintances? I'd say kind of friend, just considering what Bibbins has done for Brenner in the past. We can always refer to that in a future video or look back at it as a conclusion. But in the past, when Brenner's leg was messed up and he, injured himself, I think it was caught. It occurred within a fight, a different fight, where Brenner ended up twisting his leg in, or somebody did it to him the second time round, and Brenner wasn't that, Brenner wasn't complaining. He was like, oh, there we go. I'm going to get easy money now, the disability allowance, as he has been on since or up to his arrest. Or not arrest, until he was apprehended. Well, you can say arrest, to be honest, like the gun charges and the pending 2021 aggravated assault charge. So, yeah, that counts there. So, yeah, when Brenner did his leg in back then, it was Bibbins that did assist Brenner with driving him about to places, to shops and stuff, such as Walmart. What for exactly? Not quite sure, but Bibbins did help and look out for Brenner. How grateful was Brenner? Don't know. But there was a time, either before or after that, where Brenner did punch Bibbins in the side of the jaw, got into a bit of a fight. After that, did they make up, friends again, or enemies? Don't know, but if you want to fill in the blanks, feel free to do so. With that aside, let's focus in on Bibbins now and look back to the past trouble he's gotten himself into and the official documents which talk about it. So here we are, transitioning on over as it reads, Kevin Joseph Bibbins v. the state of Wyoming. Okay, we've heard of Wyoming before, not to do with Kevin, but to do with Don Hatley, who's in Casper City of Wyoming, as of right now, supposedly. Has he moved around since? I don't think so. Why did I just mention that? Yeah, it rejogs your memory when you see keywords, names, locations, right? And Don Hatley just so happens to be an individual that was living in Lucin around the time of what happened to Dylan Rounds. And, my question would be to you, how well does Don Hatley know Bibbins? Are they close or not? I mean, you could say they all seem to know each other in some way or another, despite maybe being in different places beforehand, but then coming together at a later point in terms of proximity and where they are located. And once again, been separated. Some taken in, others just going elsewhere by choice. Did some flee? It makes you think, right? Did some get away from the area after or during the Dylan Rounds case because they felt guilty, responsible, they wanted to get away from it, start a fresh break? I wonder. And that can link back to Kevin Joseph Bibbins, because before he got arrested in recent time for being in possession of a firearm when he wasn't supposed to. Before that, it was one of the Montello locals that did highlight that Bibbins' routine drastically changed after the disappearance/death of Dylan Rounds, right? So was that because Kevin Bibbins was responsible, or he felt extreme guilt, so he was going somewhere every day to clear his mind or to honour Dylan in a weird way? I wonder. There's a lot of random bits to think about, but whilst people can think away and come up with different ideas or theories, we're here to read this out. Official court document. Kevin Joseph Bibbins versus State of Wyoming, 1985. Gives some additional numbers and stuff. Decided the 3rd of the 20th, 1985. Supreme Court of Wyoming. There we go. Take in mind, there might be quite a bit of text and stuff to read. I'm going to try my best to read it all out. And if at any point, you can pause it yourself to read. If you can't quite see the text on the screen, feel free just to listen in to what I'm saying, okay? I do have it on reader mode, so it makes the background black and the text stand out, and it makes it less straining on the eyes, right? What do we have here? State of Wyoming appellee, plaintiff. Appeal from the District Court, Natrona County, RM Forester. So it gives some details of named individuals there within the court. There we go. Public defender. There we go. Kevin Joseph Bibbins, pro. Some more names there. If there's any names that stand out to you for whatever reason, feel free to point them out. Right. It says, this appeal is from the District Court's denial of appellant's petition for post-conviction relief. Appellant contends that his constitutional rights were violated before his plea of guilty and at sentencing. The issue, according to appellant, is whether the District Court erred in dismissing on its face appellant's petition for post-conviction relief. We will affirm. So I don't know if it'll give like a backstory to what happened, but we'll continue reading. It says, on July 2nd, 1982, on the basis of a negotiated plea, appellant pled guilty to 1 count of aggravated assault. There we go. Fine. So it was in 1982, but this appeal, this part of the court document, 1985, but the actual action took place a few years beforehand. So I don't know. It depends what else is mentioned in this article, in this document. If there's multiple dates of other crimes committed, I'll just summarize it as 1985 court document analysis rather than give separate individual multiple dates and years, right? So 1982, July 2nd, 1 count of aggravated assault. Right, so it's kind of like along the lines of what Brenner would have done and has done previously, just to take in mind. It reads, in exchange for this plea, another count of aggravated assault was dismissed. Okay. After a pre-sentence report was received and a sentencing hearing, sentence was imposed September the 9th, 1982. Appellant was sentenced to not less than 2 years and not more than 6 years in the penitentiary. The court considered the sentence a high maximum and relatively low minimum. On February 9th, 1984, appellant filed a petition for post-conviction relief according to Section 7-14-101 ET SEQ WS 1977. On February 14th, 1984, the District Court filed an order denying appellant the relief prayed for in his petition. 1. In appellant's pro se petition for post-conviction relief, he states the defendant was denied his constitutional right to a fair and impartial trial when these 2 court-appointed public pretenders failed to adequately and competently to represent the defendant for the following reasons set out below. Appellant then lists 25 complaints against his court-appointed lawyers. 2 appellant also contends that he was denied his constitutional right to a fair and impartial trial. sentencing hearing when the prosecutor either by knowingly used such perjured testimony or by knowingly using a perjured pre-sentence investigation report or actively suppressing such evidence known to be exculpatory. Appellant further claims that his plea of guilty was procured by fraud, coercion, and was involuntary. He also lists 17 separate provisions in the United States and Wyoming constitutions that he maintains were violated. However, he does not explain in any way how these 17 constitutional provisions were violated. He only reminds us of the rights protected. Right. So, what claims that Bibbins' plea of guilty was procured by fraud and coercion. So what, is that coming up with excuses? Or it genuinely happened? Anyway, the essence of appellant's petition is A, his plea of guilty was induced by fraud and coercion and was not voluntarily made. B, the prosecutor used perjured testimony and/or a perjured pre-sentence investigation report and suppressed exculpatory evidence. C, inadequate court-appointed counsel resulted in a denial of a fair and impartial trial. So I wonder if it ever did come to the case of Bibbins being caught up in the Dylan Rounds case and, I don't know, being charged in some way if evidence was found further down the line or pre-existing stuff was applied to Bibbins, would we have the same issue as what was experienced back then, I wonder? Because, not that it's always the case, but sometimes when people are in trouble and go through the courts proceedings and stuff, they may try and drag things out or put a spin twist on stuff, come up with reasons to why they did this or did that, said this. Anyway, what do we have here? Section 714.101. In quotes, any person imprisoned in the penitentiary who asserts that in the proceedings which resulted in his convictions there was a substantial denial of his rights under the Constitution of the United States or the state of Wyoming, or both, may institute proceedings under this act. Okay. The proceeding shall be commenced by filing with the clerk of the court in which the conviction took place a petition verified by affidavit. The clerk shall docket the petition upon his receipt thereof and bring some promptly to the attention of the court. In quotes, the court may receive proof by affidavits, deposition, oral testimony, or other evidence in its discretion. The court may order the petitioner brought before the court for the hearing. If the court finds in favour of the petitioner, it shall enter an appropriate order with respect to the judgment or sentence in the form of proceedings and such supplementary orders as to rearraignment, retrial, custody, bail, or discharge as may be necessary and proper. Appellant complains that 5 days after petition was filed, the court dismissed it. He concludes from the court's deposition that the court's action can only be classified as either a dismissal for failure to state a claim upon which relief can be granted or a judgment on the pleadings. The record does not support appellant's characterization of the court's deposition of his petition. The court recited in its order that it had inquired into the matter, found no legal basis for the motion, and denied the motion, not dismissed it. Right. We conclude from the recitation in the trial's court order of denial that the court did more than deny the petition on its face. We must assume that the court's inquiry included an examination of the court file. The file contained the arraignment, change of plea, sentencing hearing, and the innumerable materials referred to in footnote 1. The post-conviction procedures set out in section 714.101 does not mandate a formal hearing, nor does it require that a petitioner be brought back into court for a hearing. Whether a formal hearing is held or a petitioner is brought personally before the court seems to depend on the circumstances of each case. Whether oral testimony, depositions, affidavits, or other evidence is produced likewise depends on the circumstances of each case. Here, the trial court acted on the petition before it, considering only the court file. It was apparently determined from the court file that there was no legal basis for the petition. We cannot say that the trial court was clearly wrong. What's this one? Boggs versus State Wyoming, 1971. Before a person is entitled to an evidentiary hearing, he must present initially a substantial claim, and some specifically is required. An application is properly denied without a hearing where it states only bold legal conclusions with no supporting factual allegations. Citation. Here there were no factual allegations supporting the contention, which was in conclusory form. The law does not grant an absolute right to evidentiary hearing on the application. In this case, the allegations in a appellant's petition consist principally of bold legal conclusions and specificity. Appellant contends that his plea of guilty was produced fraudulently and coercively and involuntary. This accusation is an unwarranted conclusion and lacks specificity, but more significantly flies in the face of the record. On July 2nd, 1982, at the change of plea hearing, the record reveals the following. Let's scroll down here. The court. Do you make this plea under any threat or any coercion? The defendant, Bibbins. I make it voluntary, Your Honour. The trial court was abundantly justified in determining that there was no merit to appellant's claim that his guilty plea was obtained improperly. Appellant contends that the prosecutor used perjured testimony and or a perjured sentence, pre-sentence investigation report. Alternatively, appellant says the prosecutor actively suppressed evidence known to be exculpatory. We have difficulty identifying the testimony that appellant alludes to. Testimony is a particular kind or species of evidence, namely that which comes to the tribunal through living witnesses speaking under oath or affirmation in the presence of the tribunal, judicial or quasi-judicial. State versus Ricky, 107, 1970. Frequently, the word testimony and evidence are used synonymously, although technically the word testimony has more limited meaning than the word evidence. Right, 1955. At the sentencing hearing, the prosecutor and the defense counsel argued the case to the court, but neither produced testimony or introduced evidence. The nearest thing to testimony produced at the hearing was from the mouth of the appellant. The court invited, nay urged, appellant to tell the court anything and everything he desired. Appellant addressed the court at length. He characterized his case as one of self-defense and related some of the circumstances. However, he did not recant on his guilty plea, nor did he say he was not guilty. In fact, he said twice that he was wrong in what he did. Okay, so this is very interesting. This is still to do with that assault previously, okay, back then. Okay, so feel free to pause it if you want to, or take it in mind. Is it any different to Brenner's attitude or personality? I wonder. But claiming self-defense. That's interesting, that. Self-defense. Would Brenner ever claim self-defense or previously claim self-defense when he got caught up in an aggravated assault, such as the 2021 one? I wonder. But the bit where it says he did, Bibbins acknowledged twice that he was wrong in what he did. Interesting. Someone like Brenner wouldn't go down that route, would he? He'd keep his mouth quiet, act all cool, cold, possibly. Anyway, goes on to say, in his address to the court, appellant did not disagree with the information in the pre-sentence investigation report, which recited that he had been convicted of 1. Kidnap, assault with intent to rape, assault with intent to murder in November 1976. 2, assault with a deadly weapon in March 1978. And 3, also juvenile offences. So this is where it starts officially, listing what Bibbins has done. So just to reiterate once again, that Bibbins was convicted of kidnap, assault with intent to rape, assault with intent to murder in November 1976, assault with a deadly weapon in March 1978, and some other juvenile offences. That's quite, an assortment of criminal action in kind of a short space of time. Kidnap, assault, attempted, or not attempted, but intent to rape, assault, intent to murder. That's the key one, intent to murder. That's what Bibbins did, 1976. If he's capable of that, he could have also been capable of doing the same to Dylan, such as intent to murder, right? You read this out, it sounds worse than Brenner, right? Assault with a deadly weapon, 1978. What type of weapon? Maybe a firearm? Well, Dylan rounds could have been taken out in the same way. So fast forward years and years on, did Bibbins recreate it? You get what I'm saying? Not looking too good. Dangerous. Now, let's move on. As nearly as we can tell, the alleged perjured testimony that appellant alludes to was the pre-sentence investigation report, which was placed in the court file 18 days before the sentencing hearing. We say this because when appellant addressed the court at the sentencing hearing, he disputed the prosecutor's characterization of some of the information in the report. Specifically, appellant was wroth because his association with a woman was not recognized as a common law marriage. Also, he was in disagreement with the prosecutor regarding his status as a parole from California, and claims that whether he absconded from parole in California or whether he had permission to leave California affected the severity of his sentence. In view of the serious nature of the offence to which appellant pled guilty and his prior criminal convictions, it is inconceivable that this made any difference in his sentence. If there was something other than the two matters we have identified that appellant claims were perjured, he kept it a secret from the trial court and this court. The trial court recognised the common law relationship that seemed very important to appellant. The judge then said, "I have an inclination to believe a good deal of what you say, Mr. Bibbins." Moving on. With respect to the so-called perjured testimony, appellant also says prosecutors suppressed such evidence known to be exculpatory. Here again, the only thing he ever talked about were entries in the pre-sentence investigation report. There is nothing exculpatory in that report. Some of it, however, is favourable to appellant based on the court file. The court could determine, as it did, that there was no basis for a serious claim of perjured testimony or suppression of exculpatory evidence. Moving on. Appellant's 25 numbered complaints against assigned counsel are directed primarily against the lawyer who handled his case for a change of plea to guilty. The complaints against counsel at the time of sentencing generally pertain to the alleged perjured testimony and exculpatory evidence, which I've already addressed. In appellant's change of plea hearing, the court inquired, "The court, are you fully satisfied with her, defendant's counsel, representation of you?" The defendant, Bibbins, "Yes, Your Honour." At the sentencing hearing, appellant's counsel made a vigorous plea and arraignment for probation. As we have indicated before, there was no merit to appellant's claim or perjured testimony or suppressed exculpatory evidence. These latter two matters seem to be appellant's principal complaint against his counsel at the time of sentencing. Appellant did not complain about his current counsel at the sentencing hearing. We see nothing in the record that suggests incompetent counsel or any dereliction in handling appellant's case. Although this claim is obscured in the 25-count indictment of his two lawyers, appellant says that he was mentally incompetent at the change of plea hearing and at the sentencing. This diagnosis is subjective and self-serving and has absolutely no basis so far as we can ascertain from the record. Upon inquiry by the court, appellant repeatedly said he understands the proceedings. See, example, United States v. Cooper, 1969. We do not see any merit to appellant's claim of incompetency. It would appear that the appellant found a digest that catalogued possible constitutional violations, copied this list in his petition for post-conviction relief, and stated that this litany of violations applied to him. For example, appellant talks about the verdict. There was no verdict. He mentions search and seizure. There were no search or seizure problems. He talks about rights reserved to the people. It appears that the appellant charged in his petition every constitutional violation that he had ever heard of or could learn about, hoping that the trial court or this court could find one or more that might fit his circumstances. So maybe grasping at straws for the best outcome for him. We have carefully reviewed the entire record of proceedings. Nothing is disclosed which could support appellant's allegations that his guilty plea was induced by fraud, coercion, and was involuntary. Also, the claimed use of perjured testimony and the suppression of testimony is without merit. The denial of a fair and impartial trial because inadequate counsel has no support in the record. We hold, therefore, that the petition for post-conviction relief was properly denied. Affirmed. 1. Between September the 9th, 1982 and February the 9th, 1984, appellant was not in hibernation. He inundated the trial court with motions, petitions, affidavits, letters, advice, questions, requests, and every conceivable complaint in one letter. For example, he asked the trial judge how much he was paid on the side to send him to prison. Well. 2. Appellant was nearly depleted the staff of the public defender's office. A second lawyer from the public defender's office was appointed at appellant's insistence after his plea of guilty. 2 other lawyers prepared his trial brief, and 2 different lawyers represented appellant at oral argument. Rose, Justice dissenting. I would have reversed the denial of post-convictions relief and remanded this case to the district court with the directions to afford appellant an opportunity to amend his petition so as to include specific factual allegations supported by attached affidavits or other evidence. As the majority note, appellant Kevin Bibbins' petition for post-conviction relief consists primarily of general allegations and legal conclusions. However, instead of permitting appellant an opportunity to amend his petition to include factual specificity and evidentiary support, the majority conclude that the court file provided a sufficient basis upon which to determine the merits of the petition. The majority reason. Whether oral testimony, depositions, affidavits, or other evidence is produced likewise depends on the circumstances of each case. Here, the trial court acted on the petition before it, considering only the court file. It was apparently determined from the court file that there was no legal basis for the petition. We cannot say that the trial court was clearly wrong. Now, says, well, the court records of a petitioner's guilty plea may, under some circumstances, adequately support a claim for post-conviction relief. One, such as evidence had little, if any, relevance to the claims raised in the court bar. Appellant alleges that his guilty plea was obtained through coercion and fraud. Evidence of such wrongdoing could hardly be expected to appear in hearing transcripts. Similarly, the instances of ineffective assistance of counsel alluded to by petitioner could have occurred outside the record. The majority readily admit that the alleged perjured documents or testimony cannot be discerned from the bare record. The need for definitive factual allegations and supporting evidence from one in appellant's position in apparent and our post-conviction relief stitches from demands such specificity. Section 7, 14101 requires the filing of a verified petition for the redress of constitutional violation. Any person imprisoned in the penitentiary who asserts that in the proceedings which resulted in his convictions there was substantial denial of his rights under the Constitution of the United States or the state of Wyoming or both may institute proceedings under this act. The proceedings shall be commenced by filing with the clerk of the court in which the conviction took place, petition verified by affidavit. Directs the petitioner to state his claim nearly and to attach supporting evidence if possible. The petition shall clearly set forth the respect in which petitioner's constitutional rights were violated. The petition shall have attached thereof affidavits, records, or evidence supporting the allegations, or shall state why the same are not attached. Before a person is entitled to an evidentiary hearing, a petition for post-conviction relief, there must be set forth in the text of petition and the required supporting attachments a substantial claim plus some specificity in support of the claim. In order to justify a hearing, there must be more than a naked statement of a conclusion unsupported by an evidentiary basis. A few references down. There must not only be verified factual allegations in a petition, but the statutory requirements in that they must be supported likewise with some specificity. We recognised in that case the extraordinary nature of post-conviction relief, but said, however, if a petitioner makes a showing of innocence or probability of a different verdict by appropriate attachments to his petition which indicates a need for verification at a hearing, then a hearing may be granted. If good cause is shown, a review is available. The court in the instant case attempted to review petitioner's bold conclusions using only the court file, process doomed from the start. The proper solution for the trial court when presented with a deficient petition for post-conviction relief is to allow the petitioner an opportunity to amend. We recommend this course in Boggs v State. Whether insufficient factual allegations in support of an application to warrant an evidentiary hearing, it's usually better practice to permit the petitioner to amend his petition than to dismiss it. Oliver v United States. The ability to amend is important in post-conviction relief proceedings since a prisoner waivers all claims not raised in the original or amended petition. Any claim of substantial denial of constitutional rights not raised in an original or an amended petition is waived. Thus, our statutes can contemplate amendments as a procedural right which protects the prisoner against the loss of claims inadvertently admitted or ineffectively articulated in the original petition. In summary, Wyoming's post-conviction relief statutes, as interpreted by this court in previous cases, entitled a prisoner to an evidentiary hearing on a claimed constitutional violation if his petition contains specific factual allegations supported by affidavits or other evidence. The statutory scheme contemplates the amendment of inadequate petitions. As a general rule, this trial court should allow a petitioner a specified time within which to amend his petition to reflect the necessary factual specificity and support. If a petition remains deficient after an opportunity for an amendment, the court may justifiably dismiss without holding a hearing. Boggs v State. However, an amended petition which complies with statutory requirements should typically entitle the applicant to a hearing. In this way, courts can encourage and properly review potentially meritorious claims and at the same time avoid hearing to rule upon vague, inadequately supported contentions. I do not intend to suggest by this dissent that the district court must in every situation allow an opportunity for amendment of a deficient petition for post-conviction relief, where, for example, a petition represents the identical issues already full and perhaps repeatedly reviewed by this court. The applicant should be expected to include in his original petition the factual basis for reconsideration of his claims. Hopkinson v. District Court, Supra. However, in the present case, where the petitioner's claims have been considered by this court and where the court could provided an absolutely inadequate basis for review, the petition should not have been dismissed or denied without allowing an opportunity for amendment. Is that it? Whew, there we go. So that appears to be it there. Quite a mouthful, right? But so far down, we finally got to the point of where the previous charges and what he actually got in trouble with. And it does fall in line with what that Montello local was talking about, summarising. It's just needed and necessary to read it from here, which is official court documents, okay? Proof of it and proving and pointing out and acknowledging what Bibbins did way back then, 1976, 1978. So after reading all of that or listening to it, quite a mouthful, a lot to take in, but I'm going to try and summarise it now as best as one can. As I said, it's the first time me reading that, and to be honest, maybe the first time me reading a full-on court document transcript, which there's a lot of repetition with certain words and references and stuff. Maybe it's considered kind of boring to some. I fully understand that. But some people were saying that, you might as well just read it out completely. I guess we'll see for the future if people want a repeat of it, because take in mind that there is maybe like two to three more like court documents to do with Bibbins, different years to read out. Let me know if you'd want to listen into them as well. The importance of reading the one today, and I'll get to the summary shortly about it in case you're wondering, but the importance of reading that court document today, it listed what Bibbins has gotten in trouble with, other criminal charges from the past. Not that that court document was about every single crime he committed, but it was referencing and acknowledging what he's previously done and what he's previously got in trouble with and, the extent of it. Kind of like with the Brenner situation, where when it came to the Dylan Rounds case and that court hearing of Brenner, and it referred to his previous, trouble he's gotten involved with, like the assault, the Maryland shooting and a bit more, and then more came out at a later date too. Just stuff like that. It can reconfirm with people who this person is, what they've done in the past, and just kind of reinforce it. if that makes sense to you. But in terms of a summary, what it was getting at there, 1985, to do with Bibbins in reference to what occurred in 1982, I think, with the assault that took place. Second one being dismissed, but the original one still counting, and Bibbins pleading guilty. But it was like a petition, an appeal made, and it was acknowledged in 1985 for Bibbins to say, hey, what I originally said back then, it wasn't natural. There was additional factors which made me say I was guilty. Coercion, fraudulent stuff. You know, there's like an unnatural presence of resistance making me choose a certain pathway which I wasn't comfortable choosing. And I feel like I take that back now. And it was just taking it all into consideration there. And I think it was basically saying that there wasn't enough to support it. But as for the crimes and stuff committed in 1976, 1978, the attempted murder, attempted inappropriate stuff, the R word, and much more, right? That was just separate. This like petition thing, appeal thing, was specifically to do with the plea of the assault which took place years beforehand and how he pleaded to it. Hopefully that makes sense. If there's any experts or people that want to add to it or clear bits up, feel free to do so in the comment section. I don't normally do this, but you know, people said they wanted some kind of research, so I just wanted to present it to you and just reinforce and show proof of what Bibbins has done in the past. You know, it's okay people just saying what Bibbins has done, but if you've got the actual court documents which list it, record it, then people are probably more likely to take it seriously. And it's just to document it as we go along. As I said, there's some other court documents to get through, so who knows what could be mentioned in them. I don't know if they'll be as long, if not longer, but we'll see what happens. If it gets too long or too repetitive, if people want it, you know, cutting down a bit, just let me know down below, right? So I know what to do for the future. Whether you want it read out completely or not. I don't know if I'll do a poll here or a poll on my channel page, but I said, just want to catch up with this because I've already done part 1. This is part 2. There might be 2 to 3 more parts to this little series on Bibbins. And once again, I'm just going to highlight why we're doing it. And if people have stuck around long enough, that's great. If not, then not much can do about it. Some people out there could say, you know what we looked at today, how does that have any relevancy to the Dylan Rounds case? Well, it does in terms of a backstory, a long-winded way of doing it where you look back at a person of interest that could be tied to the Dylan Rounds case, certain factors, variables such as knowing Brenner, being friends with him in some way or another, the location kind of close to where the crime took place because Bibbins is in Lucin or was living in Lucin. So that needs to be acknowledged too. What did Bibbins see? What did Bibbins hear? If Don Hatley was going to be questioned, which he was, and Brenner, well, shouldn't Bibbins too? Didn't seem to be the case there. It kind of gone quiet, which is a bit odd. So we're looking at alternative ways of checking in on Bibbins. What is he like, or what was he like? Does it compare to Brenner, or is it worse? And if so, and in proximity, and knowing of Brenner and Dylan Rounds, did Bibbins play a role in the 28th of May 2022? With what I looked at today in terms of Bibbins' approach, behaviour and attitude, maybe making up some excuses, maybe going back on himself as well with his plea, possibly, that he could be considered more awkward or just as awkward as Brenner, but more in a verbal way. Brenner appears quite quiet, stubborn, not willing ever since to reopen up or to talk or to say anything, to confess. None of that. Stubbornness, keeping quiet, trying to keep a hold of the power dynamics. With Bibbins in an unrelated situation in the past, where Bibbins is trying to wiggle his way out, try and get a change, try and have a better outcome on him, right? Would he do the same now if in trouble in the Dylan Rounds case? Or, in a separate one, the gun charge, right? In, November the 8th, 2023, when Bibbins was charged, and that was West Wendover 300 Boulevard, near to, or at, that, concert hall, right? He was apprehended there. Could Bibbins make an attempt to try and wiggle out of that one too, with being awkward? Would he do the same in the Dylan Rounds case? Maybe. And I think the other thing to conclude with, up to now at least, because it might change as we go down the line, is that Bibbins does come off as, in a way, worse of an individual. Just as dangerous, though, as Brenner. And the reason why I say Bibbins comes off worse than Brenner is because with Bibbins, it's the R word, doing that to certain people out there, and as well attempted murder too. When it comes to Brenner, firearm charges in the past, threatening behaviour, aggravated assault, kind of like Bibbins there. Physically, fist combat, dangerous, menace to the general public. Any attempts of true murder, it was never really worded that way. The malicious or the fatal shooting, which was then dismissed and reduced to a fatal wounding, not intent to kill, but to wound somebody, it was played down. Maybe Brenner's initial aim at the time was to kill, but it wasn't officially worded like that in court documents, so not much there to go from. But with Bibbins, how it was worded in that court document, intent to murder. So there was intent to murder with Bibbins towards somebody, but with Brenner, there wasn't. So you could say that Bibbins is more dangerous, more deadly than Brenner. If you're taking it into mind nowadays, 2022 time, Bibbins, 70 or 69 years old at the time, and Brenner being 58, 59 years old at the time, 58 at the time of it happening. Bibbins is still older than Brenner, so how mobile is Bibbins to Brenner? People say that Brenner, because he's fat, he's heavier, his age in general, his leg injury. Well, how does that compare to Bibbins? Is Bibbins at the time of 2022 fit, healthy? Would he be capable of moving Dylan or getting involved in some way fighting at that age, that later on in life? Let me know your thoughts down below. But just a bit of insight to who Bibbins is and what's happened in the past with him. As I said, there is still more to come. We'll just space it out so that it gives time for people to look back at it. If you do want to rewind back, feel free to do so. And if I can, I'll try and provide the timestamp of this video where we looked at the key, most important part with the other charges of Bibbins, and I maybe can post it down below in the comment section as a timestamp, okay? So I think we'll leave it there for now. I didn't take any water when reading it all out, bit of a dry throat to be expected. You can consider it almost like torture reading all that out, but it needed to be done. And it's going to be done probably once again next time and the time after that. In between though, whether it happens today or tomorrow, I'm going to do a side video, different case to the Alex Easterling one. It might seem like jumping into the deep end of the water, deep end of the pool. Some people, or most, may not quite understand what's being referred to. Could apply to me as well to an extent in terms of the overall picture of the story. I've just not had time to fully look at it or to process it in my mind, but I just wanted to do a side video in response to the mother of Alex Easterling. Why? Because it's something that I can do and have done before, where you compare and contrast a visual finding to acknowledge whether this is the same as that or the two separate things. I just want to give them my thoughts and my opinions on that. It might not make much sense to everybody else, but that's understandable. If at some point where one case can come to a conclusion or a bit of a halt, then I can divert that attention to this one, right? But there's still lots to do, and I don't want to F it up. I don't want to disregard certain things. If there is stuff already, before the Alex Easterling thing, if there's stuff bullet pointed that needs to be done, first of all, beforehand, before getting involved in anything else, it needs to be done, right? I always like getting to a point where there's a checklist, reaching like a save point where you've done what you've done, you're up to scratch, you know what you've done, you're not confused, you can reach a bit of a cliffhanger for now, up until something new comes out. In the meantime, focus something else. And that's what I need to do. For the best transition requires certain procedure as done previously, right? So I think once I've done the Dylan Rounds mini-series on Bibbins, and I've got that all done, then I can focus elsewhere onto the other stuff, right? I don't want to start mixing stuff up too back and forth, or it just F's it all up, and it's not good. It's not a good look, and it's not good for me either, or anybody else, right? Under control for now. just do what needs to be done. And yeah, hopefully you found the video somewhat interesting. If you found it long, dragged out, I understand as well, because there was a lot of stuff to read off that document, but I didn't want to really miss anything, because if I missed out on the key point, then people wouldn't have seen it. So yeah, that's it for now. Goodbye. I'll see you next time.